Welcome to the SEDM website, and thank you for watching this video, the fourth video in our Foundations of Freedom series. This is the last and final video, and the subject of this video is willful government deception and propaganda. In this video, we will talk about the following subjects: introduction, audience for propaganda, the purpose of propaganda, fallacies, government deception, according to George Orwell, and then we'll break it up into political propaganda and legal propaganda. In the political propaganda category, we'll talk about creating and appealing to your legal ignorance, untrustworthy and lying publications, government forms, word or spin doctoring. And for legal propaganda, we'll talk about courts, quote, shaping the law, unquote, confusing domicile with residence, abusing includes and including to illegally enlarged jurisdiction, fooling you into believing that statutory and constitutional contexts for geographical words of art are the same, fooling you into believing that nationality and domicile are equivalent, confusing public rights with private rights by calling them both rights, confusing the body corporate with the body politic, identifying a compact or franchise as law, court rulings as irrelevant propaganda, falsely calling you frivolous, and individual instead of man or woman. And then we will conclude with summary and conclusions. So let's begin. Introduction. We saved the subject of propaganda and deception for the last because it is the most complex and extensive. Before commencing your study of the law and freedom on our site, it is important to know the lies you will be told by a corrupted government that may needlessly confuse you. All such confusion was engineered by a covetous, lying, thieving government. James 3:16 explains why. For where government, envy, and self-seeking, in this case of money, they are not entitled to exist, confusion and deception and every evil thing will be there. Since most people naturally avoid things that are confusing, then they ultimately are likely to avoid learning the truths found on our website. We therefore have a duty to warn you in advance of all the major sources of propaganda and fraud on the part of the corrupted public servants. This will accelerate your freedom study, make you more confident of what we teach. The audience for propaganda. In a free society, government propaganda is invented for people who do not want to hear the truth and who exercise idolatry toward government. The Bible explains this plain fact as follows: Woe to the rebellious children, says the Lord, who take counsel but not by me, who devise plans but not by my spirit, that they may add sin to sin, who walk to go down to Egypt, in this case the district of criminals, that's what Mark Twain calls the District of Columbia, and have not asked my advice, to strengthen themselves in the strength of Pharaoh, and today Pharaoh is the equivalent of the modern de facto government, thieves, and to trust in the shadow of Egypt. Therefore the strength of Pharaoh shall be your shame, and trust in the shadow of Egypt shall be your humiliation. And this shadow of Egypt really is nothing more than a public office that they forced you into so you could receive, quote, benefits, unquote. That's really what he means here, the Lord. Now go write it before them on a tablet and note it on a scroll, that it may be for time to come, forever and ever, that this is a rebellious people, lying children who will not hear and learn and obey the law of the Lord, who say to the seers, do not see, and to the prophets, do not prophesy us right things, speak to us smooth, that is, politically correct things, prophecy deceits, get out of the way, turn aside from the path, cause the Holy One of Israel to cease from before us. Therefore, thus says the Holy One of Israel, because you, that is, rebellious people, despise this word and trust in oppression and perversity, and rely on them, therefore this iniquity shall be to you like a breach ready to fall, a bulge in a high wall, whose breaking comes suddenly in an instant. And by the way, the 2008 meltdown is just at the beginning of this prophecy that he's talking about here. And he shall break it like the breaking of the potter's vessel, which is broken in pieces. He shall not spare, so there shall not be found among its fragments a shard to take fire from the hearth. The following video was posted on Russian television describes how politicians use what they call verbal camouflage to effect propaganda and deception. It also talks about how Americans just do not want to hear the truth, as a confirmation of what we just said. You can download the video at the following link, and pursuant to the RT terms of use found below, the content of RT videos are public domain and may be freely copied.
In the political theatre, it's easy for parties to change the script to suit the scene when support's not going their way. But are American voters willing to read between the lines and work out what's really meant? Artism Report Naya tries to find out.
The art of politics is made up of many things: handshakes, smiles, and a good arsenal of verbal camouflage.
Americans have a lot of trouble dealing with reality. Americans have trouble facing the truth.
Or as the late American comedian George Carlin put it, euphemistic language that conceals reality.
Poor people used to live in slums. Now the economically disadvantaged occupy substandard housing in the inner cities. And they're broke. They're broke. They don't have a negative cash flow position. They're broke.
And today, America's love affair with semantics has given birth to a new phrase to describe the rich.
Job creators in America basically are on strike.
Increasing taxes on job creators.
This administration and this president, policies are hostile to job creators.
Instead of just saying the wealthy who make over $250,000 a year, if you say job creator, then you say, well, we can't raise their taxes. They're the ones who create jobs. When in reality, when their taxes were higher under Bill Clinton, 3 times as many jobs were created.
The propensity to add softer terms to the English lexicon has surged over the decades, particularly when it comes to military-related language.
There's a condition in combat, most people know about it. It's when a fighting person's nervous system has been stressed to its absolute peak and maximum, can't take any more input. The nervous system has either snapped or is about to snap. In the First World War, that condition was called shell shock.
Today, the same condition is known as an 8-syllable hyphenated phrase void of any emotion.
Post-traumatic stress disorder.
The aftermath of war includes post-traumatic stress disorder.
Yeah. For those of you suffering from PTSD,
when it comes to wars where you have the most damaging euphemisms, like when instead of saying innocent civilians were killed, in a drone strike, you say there was collateral damage. Collateral damage, which to me is the worst expression. No, it's innocent men, women, and children were killed. And collateral damage sounds like a real estate transaction.
Allied soldiers shooting each other has become known as
friendly fire.
Kidnapping and transferring a terrorist suspect is called
Extraordinary rendition.
And the torture America's war prisoners might endure is referred to as
enhanced interrogation.
In most cases, these new words are used by people trying to define an argument or frame it in a way that will support the position that they're advocating.
And during the last U.S. presidential election, a certain demographic of voters became otherwise known as
without low information voters.
Obama went to Twitter at 2 o'clock today to encourage low information voters.
I think low information voters are stupid people, but you say low information voters because it sounds nice. Although in their defense, it could be people who are just too busy, you know, with their lives, their family, and their work, that they don't have time to focus on the election until the very last minute, and then they vote based on the hairstyle of the candidate running for president.
As America's political elite continues creating new vocabulary to soften the hard truth, a greater focus could instead be put into asking why so many issues need to be rephrased before being presented to the public. George Carlin created comedy about the strategy, but it was George Orwell who first coined a term for it: newspeak. Reporting from New York, Marina Portnaya, RT.
That was a good video, wasn't it? And it helps to emphasize the inconvenient truths avoided or concealed by propaganda. And those inconvenient truths that Americans simply don't want to hear, and the reason that they want to hear the propaganda is the following list that we're going to discuss. And the first thing they don't want to talk about and don't want to know and don't want to hear is that we don't have a government as legally defined, but a private for-profit mafia that terrorizes all those who refuse to pay them protection money at the point of a gun. And we prove this in Form 05.043. The next thing they don't want to admit and don't want to face is that you are a slave if they have the ability to impose any civil duty or obligation against you without proving you consented to them every time they want to enforce them. Why? Because the 13th Amendment outlawed involuntary servitude, but it didn't outlaw voluntary servitude. So you have to volunteer. And they don't want to recognize that. The average American does not want to recognize that, and they don't want to enforce it, and they don't want to argue about it, unfortunately, even though the law requires them to argue about it. And number 3, governments cannot lawfully or constitutionally use their taxing powers to redistribute wealth, and if they do, they're a thief and not a government. And the Supreme Court admitted that in Loan Association versus Topeka. You might want to read that case. The next thing Americans don't want to hear is that if the government can take from the rich to give to the poor, then no one can own property because we are all equal. If the rich don't have property rights and they don't have the right to deny you the use or benefit of their property, then no one has rights and no one has property. And as we said early on in our second video, the right to own property is the legally defined as the pursuit of happiness, and therefore by saying that the rich have no property rights, then no one has any property rights, and therefore no one has any happiness, and we're all slaves. And the next thing they don't want to hear is that a government that has more powers than you is a false god and an unconstitutional religion, because religion is just the worship of supernatural or superior beings, and worship meaning obedience. And so if they can command you to obey and you can't do that to them, then they have supernatural powers, and we have a religion problem, as we discussed many times throughout this series. The next thing Americans do not want to hear and do not want to talk about, especially in the media, is that the minute you ask for any kind of handout from the government is the minute you cease to be free and become a pauper with no rights. Throughout the history of America, starting with the Articles of Confederation, paupers and vagabonds were accepted from being citizens of the United States. And they have no rights. And they were selectively discriminated against in the laws, and that discrimination was lawful, and it continues to be lawful. And anyone who receives a government benefit, Social Security, Medicare, Medicaid, unemployment insurance, anything else from the government is a pauper and has no rights, and is simply a slave and a public officer in the government, and has abandoned the republic and is not a citizen. And the next thing they don't want to hear is that a government that prints money through the Federal Reserve is engaged in criminal counterfeiting and theft. You don't hear that about that a lot in the media. And the next thing they don't want to hear is that it is impossible to balance the budget because there is too much debt and the system has to implode, or the debt has to be hyperinflated away, one of the two. And finally, the last thing they don't want to hear, Americans do not want to hear, that has to be concealed with propaganda and words of art and euphemisms and everything else like they talked about, is that there is no difference between Republicans and Democrats. They are both socialists. We call them Democrats and Republicans because they're all the same. It doesn't matter. Our website has a dictionary, at least a link to a dictionary on the Family Guardian Sister site that contains an entire dictionary of all the propaganda terms you will commonly encounter from the media. You can view this dictionary as follows: Anti-Thought Control Dictionary, Form 08.013. And this dictionary is very helpful in interpreting all the media propaganda designed to control your mind and control your thoughts and make you believe things that are simply not true. Purpose of government propaganda. This is important. And here is the purpose, the many purposes of government propaganda. To conceal the pain of reality, and we just talked about what those realities are that Americans don't want to hear about. To destroy critical thinking skills and replace individual thinking with collectivist thinking. To destroy your confidence in your own reasoning abilities so that you have to appoint some expert, that has to testify on Fox News about what's really happening because you're not allowed to have your own opinion. To discredit and slander political dissidents. To condition the audience to simultaneously believe contradictory ideas. Orwell calls this doublethink. And the mechanism to create the doublethink, as that previous video showed, was, quote, newspeak, unquote, which was also an Orwell term. The other purpose, the next purpose of government propaganda is to create cognitive dissonance in subject matters that they don't want you learning about. This causes a mental block to further investigation. People simply don't want to hear it. The next purpose is to expand and perpetuate the power and influence of civil rulers at your expense. And by your expense, we mean the expense of your private rights. That's what they want to take from you, is your private rights. In other words, they want to take from you the main purpose that they were created to protect. They want to take away from you that thing that they're not allowed to take away from you, in which they swore an oath to protect. So they want to do the opposite of the reason they were created. They want to destroy rights, not create rights. And that's why we call them an anti-government rather than a government. And as we said earlier, the fact that we don't have a government, because it does this, is a painful reality that most Americans don't want to face and don't want to talk about, and which they want to pepper over with euphemisms. And they want to euphemize theft of more of your money and property by a corrupted government. So those are the main purposes of government propaganda. Fallacies. All government deception and propaganda relies on fallacies. So this is a very important subject that you want to learn a lot about, so you can recognize these tools of deceit when they're used especially by media or by a politician. Here's the definition of a fallacy: a false notion, a statement or an argument based on a false or invalid inference, incorrectness of reasoning or belief, erroneousness, and the quality of being deceptive. Now, the important word here is false. Okay? You cannot have something that's false until there's a fact that can prove that it's false. So the foundation of recognizing fallacies is to recognize what legal evidence is. You can't know what's false until you can prove that it's false. And you can't prove that it's false until you know what evidence is, and you can produce evidence to prove that it's false. And by evidence, we mean facts. We mean things that are admissible as evidence in a court of law that you can present to a jury. Okay? Everybody has opinions, but opinions are not evidence. Facts are evidence. And facts and evidence are usually something in physical form, something that's recognized in the law itself as evidence. So the foundation of recognizing a fallacy is to understand what legal evidence is. You must think critically and question absolutely everything government says or publishes in order to avoid government deception. Question authority. And here's what the Founding Fathers said about that subject. It is the first responsibility of every citizen to question authority. Benjamin Franklin. So let's talk about fallacies a little more. The first type is fallacy by equivocation. And we mention it first because that is the most common fallacy you will see coming out of the mouths of judges and U.S. attorneys and politicians. A fallacy is based on the use of the same term in different senses or contexts, especially as the middle term of a syllogism, as the badger lives in the bank and the bank is in the high street, so the badger lives in the high street. Okay, so you need to understand fallacy by equivocation. It's the most important form of deception you will find. It's the basis for all the confusion that we're going to talk about later. Fallacy by oversimplification or appeal to ignorance. And this type of fallacy, the purpose of the fallacy is to cause distortion or error by extreme simplification of a subject matter. Like they'll ask you, are you a citizen? And they won't define the context. And there are two contexts, as we'll discuss later. They may try to appeal to your emotions. This is another very common method of a fallacy. Appealing to emotions rather than logic or reason, telling you that you will be hurt if you don't accept their approach, for instance, or abusing their undeserved trust in you to convince you of something. Okay? So, they do this by pulling out the guns, by threatening you, by telling you you can't do this or you can't do that, even though they have no authority to tell you that, and so on. Fallacy ad hominem, appealing to personal considerations rather than to logic or reason by attacking your critic. Okay, so they attack somebody's credibility, they shoot the messenger essentially, rather than addressing the message. And they've tried that on us, and they've tried it on many other people that are trying to fix the government corruption. Fallacy based on popularity. Everyone believes it, therefore it must be true. This includes tradition, common practice, etc. Fallacy of many questions. Logic, the rhetorical trick of asking a question that cannot be answered without admitting a presupposition that may be false. As have you stopped beating your wife lately? This is also called leading question in legal discovery. You know, like when they're deposing somebody. They'll ask you a leading question, and leading questions are not admissible as evidence, by the way. Two wrongs make a right. Your opponent does it, so you can do it too. Therefore, there is no need to justify the correctness of the approach. And this particular approach is useful, especially in the context of equal protection and equal treatment. If whatever the government does, you can do too, because we have a government of delegated authority, and they can't have any authority you don't have, and therefore whatever they can do, you can do. And if they want to say you can't do it, then they have to apply the same rule to themselves. That's a very effective argument, by the way, if you want to use it in your defense. Red herring. They distract attention away from the main issue with less important issues, to basically distract the conversation. For instance, if they don't want to deal with any of the issues that you raise in a pleading, they'll just attack your credibility, or attack something they know that you're rabid about, or that you're angry about, or that you're dogmatic about, and that way they can distract attention from the main issues in the appeal or in the pleading. Attorneys love to do that. Another type of fallacy is a false dilemma and slippery slope. You present two options with one much less desirable so people can pick the one you want, or you rationalize the next step in the direction you want to go, telling you that you will go to jail if you don't do the thing, even though doing it is also illegal. This is how Obama got elected, because McCain was such a loser as an alternative. So basically, false dilemma and slippery slope. And as we said before, the most important fallacies most prevalently used by corrupt politicians are equivocation, confusing context for words of art, and appeal to emotions, telling you that you will be injured or hurt by learning or doing something. Learn how these fallacies work, people. Here are some examples of various fallacies and the type of fallacy. Creating and appealing to your legal ignorance, that creates a fallacy of oversimplification or appeal to ignorance. Untrustworthy and lying government publications, again, is oversimplification and appeal to emotions. Abusing includes and including to illegally enlarge government jurisdiction, that's a fallacy by equivocation. Fooling you into believing that statutory and constitutional contexts for geographical words of arts are the same, that would be a fallacy by equivocation. That's an extremely frequent thing. You see that all the time on just about every government form. Fooling you into believing that nationality and domicile are equivalent, that happens on passport applications and driver's licenses sometimes, and that's also a fallacy by equivocation. Confusing public rights with private rights by calling them both rights, that's a fallacy by equivocation. Confusing the body corporate with the body politic, fallacy by equivocation. You see that a lot in courtrooms when they're talking about state and United States. If you'd like more training on fallacies, there are several YouTube videos that you can watch which teach you, and these are college courses, so they're really helpful in familiarizing you with how fallacies work. Government deception. George Orwell. Here's what he said about how governments deceive the people. And he had lots of words that he used, newspeak and doublethink and so on. But the purpose of fallacies is to accomplish this type of deception that Orwell talks about here, especially in his book 1984, which is extremely scary. Doublethink means the power of hypocritically holding two contradictory beliefs in one's mind simultaneously and accepting them both. Now, obviously, you can't engage in doublethink unless you're ignorant. So a necessary precursor to doublethink is an ignorant populace. You cannot manipulate people to engage in doublethink who are fully informed. And that's why we focus so much on education on our website. He also said, George Orwell said, during times of universal deceit, telling the truth becomes a revolutionary act. A lot of what we teach, is treated by the outsiders as, revolutionary, but they're not revolutionary. It's just that everybody else has been so thoroughly deceived and uninformed. And that ignorance breeds, the false belief that you're a revolutionary. Orwell also said that political chaos is connected with the decay of language. One can probably bring about some improvement by starting at the verbal end. And that's why we focus so much in this presentation on language and words of art and the deception they create. Orwell also said that political language is designed to make lies sound truthful and murder respectable and to give an appearance of solidarity to pure wind. And finally, he said, sometimes the first duty of an intelligent man is the restatement of the obvious. And most of what we talk about is precisely that. It's a restatement of what ought to be obvious and what ought to be what we regard as common sense, but technically sounds revolutionary to most average uninformed Americans. So this completes our basic introduction, and now we're going to break the propaganda down into two categories: political and legal propaganda. Political is what you're going to hear from the politicians and the administrators and the administrative offices like the DMV and the Social Security office and the employment department and all that sort of stuff. Okay, so first we'll talk about political propaganda, and then we'll do the legal propaganda. Now, as we said before, fallacies rely on an uninformed audience. So the first thing they have to do in order to make the fallacies work on you and make you into a victim of their scheme is to create legal ignorance. And public schools deliberately teach students nothing about law or litigation. And it ought to be no surprise that this happens, because who runs the public schools? Well, the government. And the government doesn't want the sheep to know who's in charge, do they? Which is the people they're supposed to be educating. So they brainwash you, essentially, by making you completely out of your element, completely uncomfortable, completely fearful whenever you deal with a legal subject, because you never learned anything about it. And the absence of legal education in the public schools has made the legal profession into the equivalent of a priesthood, and the judge into a priest of an unconstitutional civil religion. And we wrote a whole document about that subject entitled Socialism, the New American Civil Religion. And so the judge is the priest, and the attorney is the deacon of the church, and the Bible is called the Code or the Franchise Code, and the courthouse is basically the church, and presumption serves as an equivalent for religious faith. That's how their religion works. And so presumption serves as a substitute for facts or evidence, even though this violates due process of law. Okay, so that's how all religions work. They're based on faith or trust of some kind. Okay, and so presumption is their counterfeit religion, the basis for their counterfeit religion, because it serves as an equivalent of religious faith. But it's unconstitutional in a constitutional court. And the presumption also serves as a substitute for faith in a religious context. This turns the courtroom into a religious exercise, the court into a church, hearings into religious ceremony to which the government or civil rulers are obeyed and thus, quote, worshipped, unquote. And on the subject of manufactured legal ignorance, these quotations are very useful. Politicians prefer unarmed and illiterate peasants who are surety for public debt and peons. That's the position they want you to be in. That's the ideal, quote, citizen, unquote, that they want to have. And politics, Greek, poly equals many, and ticks means blood-sucking insects. So remember that. And the most frequent method of political propaganda and deception is untrustworthy publications. For instance, the courts and the IRS both say you can't trust anything the government publishes other than the positive law itself. And here's their own quote on that subject. IRS publications issued by the National Office explain the law in plain language for taxpayers and their advisors. While a good source of general information, publications should not be cited to sustain a position. And what that means is that you cannot base any position you have, anything you believe on, and especially in a court of law, on anything the IRS publishes. And that would include every one of their forms, the 1040, the 1040-NR, and all of their forms. Okay? The publications are grossly oversimplified and abused as a way to persuade people politically, but avoid exposing factual and legal conflicts they propose. For instance, they frequently use the term sources within the United States, but they don't want to talk about which of the 4 United States they mean, and we'll talk about that later. This oversimplification of the publications leads to fallacy by equivocation, oversimplification, and appeal to ignorance. They know that you don't know anything about the law, and they exploit that fact to cause you essentially to commit a crime and fill forms out knowingly false. And then they claim plausible deniability and that they didn't know as their only real defense for that tactic. It's extremely evil. The main thing that makes government publications deceptive at best and false at worst is the following. They refuse to define key terms like state, United States citizen, employee, taxpayer, etc. They presume the ordinary meaning of the statutory terms and yet enforce the legal meaning, that is the statutory meaning. And that goes back to what Orwell described as doublethink. They essentially enforce 2 completely different ideas and approaches to the same subject, and both of those conflict with each other. And what makes them susceptible to the doublethink is their own legal ignorance. And so when they recruit people to work in the IRS or in an administrative bureau in a government agencies, they're selected specifically because they're legally ignorant, and so they make good little pawns to do all the criminal dirty work that most governments are chronically engaged in. They also cause a crime, perjury, and a violation of due process resulting from presuming the ordinary meaning of words. Because if you presume the ordinary meaning and yet you don't, and yet you enforce the statutory meaning, then essentially you are causing a lot of crimes to be committed, and we'll talk about what some of those crimes are. The main crime is perjury, and the second crime is that you are causing essentially identity theft of the people that are filling the forms out, because they're pretending to be public officers in the government engaged in franchises, and yet they can't lawfully do so. And so you're promoting essentially the abuse of government property. All franchises and offices are property for personal gain, and it's theft. It doesn't matter how pretty a word you put on it. It's still theft, and it's crime. It's identity theft and a lot of other things. And the other reason that makes these publications deceptive is that they refuse to obey the rules of statutory construction pertaining to the word includes. Because remember, the purpose of the rules of statutory construction and the purpose of law itself is to limit and confine government power. And what they try to do is presume whatever they want all of these definitions to mean. And essentially that removes all the limitations upon their authority. And the U.S. Congress defined 50 U.S.C. 841 defined essentially a communist government as one that refuses to recognize the lawful limits upon its authority. And the includes is just one of many different ways to exceed those lawful limits. And so in a sense, they're communists. Question: if the courts say you can't trust anything the government publishes or says, then why in God's name would you want to sign a government form under penalty of perjury stating that it is factual and truthful? Shouldn't the government or someone in the government at least have the same risk in ensuring the accuracy of their forms and publications? If you have to take the risk of signing under penalty of perjury, shouldn't they have to take the risk to even publish the forms to guarantee their accuracy? That would seem to us to violate the concept of equal protection and equal treatment. Now, doesn't it? And doesn't this violate the constitutional requirement for equal protection and equal treatment? We've got a whole document about that. That document is entitled Requirement for Equal Protection and Equal Treatment. If you'd like to know more about why you can't trust any government publication, especially IRS publications, and every one of the forms that they offer to the public, then please read Reasonable Belief about Income Tax Liability, Form 05.007, on our Forms and Publications page. Fraud on with government forms. The purpose of government forms is to associate you with a civil or legal or franchise status that they can regulate and control, usually illegally. And more specifically, the purpose is to convert your private rights into public rights without your knowledge. In other words, to steal from you. The most important block on government forms is the status block, such as individual, taxpayer, citizen, and so on. Agencies that accept government forms will speak of the franchise status on the form as a political or constitutional status, but at the same time they will presume that it's a legal or statutory status. This is the heart of what we call form fraud, perpetuated by a corrupted government. And it's essentially identity theft. That's what courts do. That's what administrative agencies do, like the DMV and the Social Security Office. It's all identity theft. It's identity theft because they're trying to associate you with a public status that you either can't have or don't want. And if they correctly presented to you that you aren't required to have that status and that they would protect your right to not have it and that they would put all the available statuses on the form, then most people would never volunteer, now would they? So that's the heart of the fraud. Identity theft. All IRS forms are taxpayer forms. You can't use any IRS form as a non-taxpayer without doing one of the following to protect your status as a private human being and not an individual or person or public officer or anything else. Providing a mandatory attachment that defines all terms to make you a non-taxpayer or not a government customer called a person, and to modify the form to add non-taxpayer status or non-resident status, and to provide your own form as an attachment, a mandatory form, or a substitute, actually a substitute form. So if they try to hand you a 1040, then you could use your own replacement and call it because the 1040 says U.S. individual in the upper left corner, and if you're not an individual, you can't use that form. So you have to make your own form. And we have an equivalent form on the site that replaces that form called Form 15.001. You might want to look at it. Another type of political propaganda is word or spin doctoring. And this is done with several different terms. And, the RT video we showed earlier just hints at how the forms are euphemized or made to appear different than they really are. And here are just a few of those words that you're likely to see on government forms, especially because, political propaganda usually occurs on government forms. Okay, the forms are treated as a political document rather than a legal document when they ask you to fill them out, and then they turn right around after you submit them and sign them and treat them as legal documents. They can't do both. They either do one or the other. If it's a political document, they can't even hand it to you because they can't regulate private rights. And if it's a legal document, then they have to respect the definitions, and they have to talk about the definitions. They can't do both. Otherwise, we're talking about doublethink, aren't we? So here are a few examples. Law means your private law, public officer employee agreement, not that which applies equally to all. You have to volunteer to be such a public officer before it applies to you. So if they say that it's law, what they're really talking about, what you have to presume is that they're talking about law for basically public officers in the government. In other words, public law for public officers. And it doesn't apply to everybody, obviously, because if it's a franchise, it only activates or acquires the force of law with your consent. And therefore, it's not law for you if you're not a public officer. Tax. And the meaning is what you pay is not a tax as legally defined. Taxes cannot be paid to private citizens and can only be used for the support of the government. If they are used to pay private citizens, then the government is a thief and a Robin Hood. And the Supreme Court said in Loan Association versus Topeka that the government cannot use its authority to tax to redistribute wealth or take from A and give to B, because that's theft. Government cannot be a thief. The government is there to prevent thievery rather than promote it. Government. They are not a government if they won't protect your private rights from injury by them without paying you a bribe. Without paying them a bribe. They are a protection racket that you have to bribe to get them to simply leave you alone. So that's what a government really means, okay, to them. Because based on the way they behave, not based on the legal definition, but based on the way they behave, that's what they are. That's what they define as a government. Court. Franchise courts are not courts in a constitutional sense. Constitutional courts are only in the judicial branch. Franchise courts are in the executive branch, and they're agencies in the executive branch. They're either boards or arbitration boards. The original tax court was called the Board of Tax Appeals, and it was fraudulently renamed to disguise its nature as a non-court. And you can read about this in the Supreme Court case of Freytag versus Commissioner, if you don't believe us. Return. Okay, you can't return what never belonged to the government to begin with. Now, can you? Okay, if what you put on a tax return really is private property and private rights, then why would you want to return it to somebody else if it's yours? Only public officers who already work for the government can return anything. So this is another example of doublethink, okay? People don't even question what return really means in the phrase tax return. Okay, but that's what it means. Internal, in the phrase Internal Revenue Service. Okay, what that really means is internal to the government, not internal to the constitutional geographical United States. And we prove this in Form 505.005. The Internal Revenue Service only gathers revenues from among fellow public officers in the same branches they are, because they cannot take money from members of other branches. Otherwise, they're violating the separation of powers. So what branch are they in? We'll give you a hint. They're not in any branch because they're not part of the government at all. They're a private debt collector corporation for the Federal Reserve. And as a matter of fact, their authority was to do that was created when the Federal Reserve Act was passed, almost simultaneously in 1913. First, they enacted the 16th Amendment, and then shortly after that, they did the Federal Reserve Act in December of that same year, 1913. So they're just basically a private corporation that collects debts for another private corporation called the Federal Reserve. Citizen. Citizen does not mean and all these terms are terms you're going to see on government forms. And we're telling you the real definition. We're not telling you what the legal definition is. This is the de facto definition. This is what it really is based on the way they behave. Okay? Citizen does not mean a constitutional citizen on a government form, but a public officer franchisee in the U.S. government. That's what it really means. Okay? It's a job description. It's an employee. It's a public officer. That's what a public officer is, an employee or a contractor of some kind. Okay? Resident means a party consenting to act as a public officer statutory employee and has nothing to do with any geographic place. The equivalent of a government contractor. That's what a resident is. The only place in the entire, Internal Revenue Code where citizens, in fact, are made liable is in Section 911, and in that capacity, which is citizens and residents abroad, and they're grouped together. And the reason they're grouped together is because a citizen, while he's abroad with a foreign domicile, essentially is a resident in respect to the country that he's in under a tax treaty. So even then, he'd be a resident. So the real resident, the real customers, the real employees are all residents in the Internal Revenue Code. Even the citizens are residents in respect to the country they're in under the tax treaty. Your Social Security number, they like to use that phrase a lot too. It's only yours, your property, if you are working as a public officer at that time. Otherwise, it's theirs. And it's a fraud to call it yours according to 20 CFR 422.103D. Okay, that section says, and the regulation says, that the number belongs to the government and not you. So if they say it's your Social Security number, indirectly they're asking you two questions. First of all, they're asking you, are you a public officer on official business? Is the first question. And the second question is, if you are, what's your license number to act in that capacity? So if you give them a number, you answered both questions. First, you said, yes, I work for the government. And secondly, here's my authority to do so. And here's my license to do so, my de facto license called the Social Security number. And finally, state on government forms. A legal person and federal corporation and not a geographic territory. All those who are in, quote, in this state, unquote, in fact, are voluntarily serving as public officers within the legal person's state as an agent of said person. See Form 05.024, corporatization and privatization of the government. If you'd like to learn more information about the word and spin doctrine, you may want to refer to the following subjects and articles on our site. Citizenship status versus tax status, Form 10.001. Why you are national, state national, and constitutional but not statutory citizen, Form 05.006. The meaning of the words includes and including, Form 05.014. About SSNs and TINs on government forms and correspondence, Form 05.012. And you're not a citizen under the Internal Revenue Code, and you're not a resident under the Internal Revenue Code. So now let's get into legal propaganda. And this is propaganda you're going to hear out of the mouths of licensed attorneys, out of U.S. attorneys, out of state attorneys, out of the district attorney in your municipality, and out of especially judges in courts. Okay? And the most prevalent thing, that type of legal propaganda, is courts, quote, shaping the law, unquote. The U.S. Supreme Court says that the purpose of appellate courts is to, quote, shape the law, unquote. And we're going to show you a video in a second proving that, right from the horse's mouth. What they really mean by, and keep in mind as you watch this video, that what they really mean by shaping the law is to perpetuate and protect the unconstitutional inequality that is the source of all of their power, and to protect the criminal activities of fellow public servants, and to abuse language to achieve political objectives, and to cause the courts to thereby act in a political capacity in violation of the separation of powers doctrine, and to deceive the public about what the law requires, and in fact even deceive the public about what law is for them. Okay, to call a franchise law for everybody, or to just call it law, as we'll talk about later, is fraud. Okay, it's not law for everybody; it's private law, and of course they conveniently omit the private in front of that phrase so they can fool you into believing that you have to obey something that it isn't law for you. We're not suggesting that it isn't law for somebody. We're just saying it isn't law for everybody. And finally, the purpose of, quote, shaping the law, unquote, is to censor critical information about violations of rights by the government from rulings of the court. The remainder of this presentation, to the end, will focus on how both courts and lawyers, quote, shape the law, unquote, according to Justice Scalia himself.
Well, it's, any appellate court does more than decide the case in front of it. In fact, that's to my mind, the least important thing that the court does. Any appellate court shapes the law, which is why appellate judges ask hypothetical questions, which lawyers don't like. But the reason you ask them is because, frankly, sir or madam, I don't care whether your client wins or loses this case. I am not about to give victory to a seemingly deserving party in this one case at the cost of causing injustice in hundreds of cases down the road. So the primary role of an appellate court, and especially that appellate court which is at the apex, is to decide cases on grounds, on bases that will produce justice overall in the long haul.
So now you heard it. Justice Scalia himself admitted that the purpose of courts is to shape the law. George Orwell also described what shaping the law really means. And here's what he said. The great enemy of clear language is insincerity. When there is a gap between one's real and one's declared aims, one turns, as it were, instinctively to long words and exhausted idioms like a cuttlefish spurting out ink. And what does that ink do? It conceals reality. It conceals the thing that they want to conceal, which is the truth. And that truth we listed, earlier, after the RT video, all those truths that the American public doesn't want to hear, that the politicians don't want to hear, that the courts don't want to talk about, all of those truths are the things they're trying to disguise with their ink, their words of art, their propaganda. Okay? Now, now we're going to talk about all the various types of ink that they produce. All the deceptions that they produce, and all the types of using words of art, using, what we called equivocation. Okay, equivocation, we said, was a confusion of context. Okay, a confusion of words. To remove dichotomies. Okay, to make people think that two things are equivalent. And the most important one that they like confuse is, and that's why we put it first, is domicile and residence. They're not the same thing. Courts, you can have only one domicile, but you can have as many residences as you want. Okay, but the courts and the lawyers frequently try to confuse domicile with residence. Federal Rule of Civil Procedure 17B mandates that all civil statutory law used in civil litigation must derive only from the civil domicile of the parties, not the residence of the parties, but the civil domicile. But they won't talk about domicile. As a matter of fact, if you search the entire Internal Revenue Code for the word domicile, it's only mentioned in the context of estate taxes. Everywhere else they call it residence, and they don't tell you what residence means, but we'll tell you what it means. It means an employment agreement, a contract with the government. And we'll show you that later, okay? The meaning of resident. In most statutory law, it means a government contractor participating in franchises, okay? In the common law, however, it means a foreign national with a domicile within the territory of the government to which the term relates. So the question is, which resident are they talking about? You might want to ask that, okay? And to avoid the issue entirely, you might want to say you're a non-resident. So you don't have to argue with anybody because you're not a customer. And once you're not a customer, all they can do is dismiss the case for lack of jurisdiction, which is perfect because they should leave you alone. That's what a sovereign is. He's somebody who's left alone as a matter of right and as a matter of law, not as a matter of franchise or privilege, okay? An example of who the real resident is that they are referring to, here's one example that we found. And by the way, this example was immediately hidden as soon as we pointed it out because it's so telling. All right? It's no longer found in the regulations. They replaced it with a temporary regulation to hide the fact. That doesn't mean it was wrong. It just means it told the truth too plainly. But here's what they think a resident is. Okay? And the title of the regulation, 26 CFR 301.7701-5, domestic, foreign, resident, and non-resident persons. Okay? A domestic corporation is one organized or created in the United States, and that United States, by the way, is a legal person. It's not a geographic place. And we'll talk about that later, including only the states, and during the periods when not states, the territories of Alaska and Hawaii and the District of Columbia, or under the laws of the United States or any state or territory. A foreign corporation is one which is not domestic. Duh! A domestic corporation is a resident corporation, even though it does no business and owns no property in the United States. A foreign corporation engaged in a trade or business, and that there's your word of art right there. The red flags ought to come up every time you see words of art. In this case, trade or business is a word of art. Okay, and it means a public office in the United States. So it's saying a foreign corporation engaged in a public office within the United States is referred to in the regulations in this chapter as a resident foreign corporation, and a foreign corporation not engaged in a trade or business within the United States is a non-resident foreign corporation. So how did you become a resident if you're a foreign corporation? Okay, you engaged in a trade or business. And what is it? It's legally defined as, in 26 U.S.C. 7701A26, as quote, the functions of a public office. And the rules of statutory construction do not permit adding anything to that meaning. So, how did that foreign corporation engage in a public office in the United States? Is the question. And if it didn't, then it continues to be foreign and a non-resident, which means it's beyond their jurisdiction. So, the other thing you ought to get out of this is that the activity, the trade or business activity, trade or business right here, the trade or business activity is what creates the legal person. And that legal person is the resident. Okay? That legal person, the office, is the resident. Okay? Not the person filling the office. In this case, the foreign corporation filling the office is not the resident. Okay? The office is the resident. Okay? And the foreign corporation is surety for the office. Okay, and continues to be a non-resident. But they're surety for the office, so they have to answer in the federal court under Federal Rule 17B, because under that rule, there are only two ways that the court can have civil jurisdiction. Either you have a domicile within the exclusive jurisdiction of the sovereign, or you represent a corporation as a public officer that has a domicile. The corporation itself has a domicile. Okay? So you either have to be domiciled in the place, or you have to represent an entity that is domiciled. And that entity is a public office that they're talking about right here. Okay? Moving on. Okay? A partnership engaged in a trade or business within the United States is referred to in the regulations in this chapter as a resident partnership, and a partnership not engaged in a trade or business within the United States is a non-resident partnership. There's the same theme again, okay? And what kind of partnership can they be talking about here? If they don't have if they don't have authority over private rights, they're not talking about a private partnership. So what kind of partnership is it? We'll give you a hint. It's a partnership between the United States government, meaning a contract or an agreement, and that partnership produces agency on the part of the contractor, whoever that is. You know, in this case, it's you if you filled out the government form, the SS5 or the SS4 or the W4 or anything like that. That's how they pretend to get jurisdiction. And it says whether a partnership is to be regarded as a resident or non-resident is not determined by the nationality or residence, and by that they can only mean domicile, of its members, or by the place in which it was created or organized. Okay? So what they just admitted there in black and white is that you become a resident by engaging in the activity. And that activity has to meet all the legal requirements for engaging in it. So if it's a public office, then you have to be appointed or elected. That's the only way you can become such an officer. The franchises, such as the vehicle code or the traffic code or the family code or the tax code, all of those franchises do not create new offices. They simply regulate existing offices. Nowhere in any of those franchises that we've ever found is the ability to create a new office acknowledged. And it would be a crime, and it continues to be a crime, to elect, quote, elect, unquote, yourself into an office by filling out a government form. You have to run for political office before you can even be a public officer, okay? Or the president has to appoint you as one of his appointees. That's the only way you can be a public officer. And not everybody who works for the government is a public officer. A very small subset of those people are actually public officers. They're all described in 5 U.S.C. Section 2105. If you'd like further information on this dichotomy, this deception used with domicile and residence, please see Why Domicile and Becoming a Taxpayer Require Your Consent, Form 05.002, or You're Not a Resident under the Internal Revenue Code. Because a resident, whenever you see that word resident, you should think government contractor, government worker. That's what it is. That's what a public office is. It's a government contractor or government worker. The next most frequent source of deception, legal propaganda, is includes and including. The words includes and including are chronically abused to, number one, allow government workers to add or presume anything they want to the statutory definitions. And, of course, this violates the whole reason for the existence of law to begin with, which is the definition and limitation of the government's power. Okay, if they can add whatever they want to the definitions, then there is no law. Because they can make the law mean and include whatever they want. And as we said earlier, the very essence of being a communist in 50 U.S.C. 841 is a failure or refusal to recognize the limits placed upon the law, upon the authority of the people in the government. That's what a communist is. So anybody that pursues this approach is a communist by the government's own definition. The additional purpose of using includes and including is to remove all limits on the delegated authority of the government. This violates the 10th Amendment and turns the government into a communist government, and to illegally expand the implied meaning of statutory definitions, and to unlawfully enlarge federal jurisdiction beyond federal territory and thereby achieve an unconstitutional result. And by unconstitutional, we mean Article 4, Section 4 in the Constitution is the only mandate found anywhere in the Constitution, and it says that the government has to protect, the federal government has to protect the states from invasion. And it becomes the invader if it refuses to recognize the jurisdictional limitations upon it within states of the Union. Okay, and franchises are the main method to exceed that jurisdiction. And they're not allowed to be offered, but they are offered, and that's where all the problems come from, because they create inequality and they result in an invasion of the states, and the Supreme Court has even called that an invasion. And finally, the abuse of the word includes causes the reader to believe things that are simply not true. The rules of statutory construction forbid adding anything or class of things to statutory definitions. Statutory definitions replace rather than enlarge ordinary meanings. And when statutory definitions are provided, they supersede rather than enlarge the ordinary or common or English meaning of words. Okay, so if they provide a definition, then you cannot use the ordinary meaning. You cannot presume that the ordinary meaning applies. You have to use what's provided in the statutes. Why is this? Because the law functions as a limitation of power on the government and cannot do so if the definitions are not limiting. Hello? And the Supreme Court recognized this fact in the following case, Stenberg versus Carhart, 2000, 530 U.S. 914. When a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. Meese versus Keene. It is axiomatic that the statutory definition of the term excludes unstated meanings of the term. And Collaudy versus Franklin, as a rule, a definition which declares what a term means excludes any meaning that is not stated. Western Union Telegraph versus Lenroot, and so on. It says, that is to say, the statute read as a whole. And by as a whole, what they really mean is, you can say this word means something here in one part of the statute, and then you can add to the definition later in another part. Okay, but if there's no additional provision that adds what you want added, then it doesn't apply. Okay, for instance, if United States is defined as the District of Columbia in 7701A9 and A10, they can't add, and if the term state is defined as the District of Columbia, they can't add a constitutional state to the meaning. So for further information, we've written an entire memorandum of law on the meaning of the words includes and including that you can use to defend yourself from this sort of basically legal propaganda by judges and attorneys who want to usurp power. The next type of legal propaganda is deliberately confusing statutory and constitutional context. This happens all the time, and especially in the context of citizenship. The most frequent source of deception from the judicial and executive branches is to confuse the context of terms in government publications and in statutory law. Okay? You really need to learn this subject. Confusing context is a fallacy called equivocation, as we said earlier, and confusing context only works among legally uninformed audiences, which includes the average American. There are two contexts, only two contexts for legal terms, the constitutional and the statutory context. Geographical terms have completely different meanings in these two contexts, such as state, United States, citizen, etc. Context is everything. In real estate, the only three things that matter are location, location, and location. In law, the three things that matter in deducing the scope of a statute are context, context, and context. The ability to discern context is usually the last skill that one develops when learning law because it requires so many other skills to fully master. And the public fool that is school system is designed to ensure that you never learn how to discern legal context. Public servants don't want to hand you the key to your legal chains, slave. And most Americans who are legal neophytes never learn this skill. But you are dangerous to a corrupted government in a courtroom if you know this skill. Read the law and insist on properly applying it as a jurist and a litigant. Listen up. Learn this skill. And on this subject, the Bible says in Hosea 4:6, that is God's people are destroyed for lack of knowledge. Misunderstandings about context are the main source of needless arguments, controversy, and conflict in the freedom community. And judges and legislators know that the vast majority of Americans do not understand legal context or words of art. That is why they exploit them so frequently to deceive, confuse, and enslave the populace. And violate their oath, by the way. Deception originating in the failure to properly discern context is how corrupt judges and legislators with a criminal and financial conflict of interest pit freedom fighters against each other so they can never damage the government's plunder program. The only way to prevent this tactic is to learn about context and words of art, people. If you want to learn how corrupt judges abuse context and words of art to deceive and enslave you, please read The Meaning of the Words Includes and Including, Form 05.017 or 14, and Why You're a National, State, National, and Constitutional but Not Statutory Citizen, Form 05.006. And on this subject, here are some really important quotations we want to emphasize. Senator Sam Ervin, during the Watergate hearings, said, quote, "Judicial verbicide is calculated to convert the Constitution into a worthless scrap of paper and to replace our government of laws with a judicial oligarchy." Okay, in other words, the judiciary becomes essentially the de facto government, and they do whatever the heck they want by adding whatever they want to the meaning of definitions. And Confucius said, when words lose their meaning, people will lose their liberty. If a word does not have a predetermined meaning, or if the judge can decide whatever he wants it to mean, then there are no laws. We're completely lawless, and the judge is the real ruler rather than the law. George Orwell also said, "The great enemy of clear language is insincerity. When there is a gap between one's real and one's declared aim, one turns, as it were, instinctively to long words and exhausted idioms like a cuttlefish spurting out ink." And we're showing you all the ways that the cuttlefish spurts out the ink. And the cuttlefish is the thieves in the government, the district of criminals, as Mark Twain called it. And finally, Aristotle, in Metaphysics Book 4, said, "If a word has an infinite number of meanings, or even a subjective meaning, it has no meaning, and our reasoning with one another has been annihilated." So law at that point is just a convenience to disguise what's really a judicial oligarchy, as Senator Sam Ervin said. So let's delve more into the two contexts that we talked about, constitutional and statutory. The constitutional context relates to states of the Union and excludes federal territory and legislative jurisdiction of Congress over sovereign states of the Union. The sovereign states of the Union, constitutional states, are foreign sovereigns under international law, with very few exceptions. And the Constitution defines the United States as the states of the Union, and we mean in a geographic sense, okay? So the United States in a geographic sense only has one meaning in the Constitution, and it means states of the Union and excludes federal territory. The statutory context, on the other hand, relates to federal territory and excludes constitutional states of the Union. And it defines United States as federal territory and not within any state of the Union. Okay, so these two meanings of United States are different contexts. They look the same. They both say United States, but they have completely different meanings depending on the context. A constitutional citizen of the United States, therefore, is a statutory non-citizen national. They are not the same contexts. You cannot be a constitutional citizen and a statutory citizen at the same time. You can only be one or the other. Okay, if a constitutional citizen under the Constitution, 14th Amendment, for instance, is a non-citizen national under Title 8 of the U.S. Code, Aliens and Nationality. Remember that when you're filling out your next government form. United States in the Constitution, and here's why we say this. State, as used in the Constitution, does not include federal territory. And here's an example, Downs versus Bidwell, 1901, U.S. Supreme Court. The members of the American Confederacy only are the states contemplated in the Constitution, meaning federal statutory states are excluded, and excludes from the term the signification attached to it by the writers of the Law of Nations. This case was followed by Barney versus Baltimore and blah, blah, blah. The same rule was applied to citizens of the territories of New Orleans in New Orleans versus Winter, in which an attempt was made to distinguish a territory, federal territory, from the District of Columbia. But it was said that neither of them is a state in the sense in which that term is used in the Constitution. So state in the Constitution does not include statutory states. Found in the Internal Revenue Code, found in any one of the federal franchises, including the Social Security Act, and so on. Federal territory is not within the constitutional United States. And here's proof of that. Indeed, the practical interpretation put by Congress upon the Constitution has long continued and uniform to the effect that the Constitution is applicable to territories acquired by purchase or conquest only when and so far as Congress shall so direct. So a territory does not become a constitutional state until it gets incorporated into the Union. Otherwise, it's a foreign state in respect to the states of the Union. And by foreign, we mean that the people in them are aliens, statutory aliens. They're not constitutional aliens, they're statutory aliens. Okay? Two contexts, constitutional and statutory. Every word should be seen through that filter of what the context is. And the next proof that federal territory is not within the constitutional United States is the same case. We are therefore of the opinion that the island of Puerto Rico, which at the time was a territory, is a territory appurtenant and belonging to the United States, and that United States they mean there is a legal person, okay? The corporation, United States, but not part of the United States, and we say star, 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 meaning the constitutional United States, meaning the geographic United States within the Constitution, within the revenue clauses of the Constitution. So in other words, territories are not the subject of, are not within the, quote, United States, unquote, as used geographically within the United States Constitution. And here's some more examples. O'Donoghue versus United States. Note that the use of, quote, not part of the United States within the meaning of the Constitution, implying that there is only one geographic meaning and that that meaning excludes federal territory. Quote, as the only judicial power vested in Congress is to create courts whose judges shall hold their offices during good behavior, it necessarily follows that if Congress authorizes the creation of courts and the appointment of judges for limited time, it must act independently of the Constitution upon territory which is not part of the United States within the meaning of the Constitution. And notice they use the phrase the United States, not one of the United States, but the United States within the meaning of the Constitution. And the 13th Amendment, note that the, quote, subject to their jurisdiction, close quote, implies, within the 13th Amendment, implies the constitutional states and not federal territory or the statutory state found in 4 U.S.C. 110D. And here's an example, Section 1 of the 14th Amendment. Neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Notice the duality here. The United States and their jurisdiction. So this United States they're talking about here means states of the Union and excludes federal territory. Because federal territory, such as the District of Columbia, Puerto Rico, and so on, are not within the meaning of their within the Constitution. Moving on. United States can have two meanings in the Constitution. Constitutional, geographical or legal. Okay? The only geographical meaning within the Constitution means states of the Union. And it excludes federal territory for everything other than Article 1, Section 8, Clause 17, as pointed out in Downs. And United States in a non-geographical sense refers to United States Corporation as a legal person, or what the U.S. Supreme Court calls, quote, the body corporate, unquote. Examples are the following terms from Article 1 of the Constitution. Congress of the United States. Obviously, that's not a geographical meaning. That means the legal person, the corporation United States. And the United States is a corporation. 15 USC 3002 15A. Or, I'm sorry, 28 USC 3002 15A says that it's a corporation. Senate of the United States, President of the United States, Treasury of the United States, Office under the United States. So these are all corporate terms, legal person terms. So there are, once again, two contexts within the Constitution. One of them is geographical, which always means the states of the Union, excludes federal territory, and the other one is a legal person as a corporation. But the important thing to remember is there's only one geographical meaning in the Constitution. United States in statutes. On the other hand, here's the other statutory context for geographical terms. The definition of United States in federal law for the purposes of statutory citizenship. Look at this. It's 8 U.S.C. Section 1101, Aliens and Nationality, Section A38. The term United States, except as otherwise specifically herein provided when used in the geographical sense, means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, and the Virgin Islands of the United States. And here's the definition of continental United States. The term continental United States means the District of Columbia and the several states, except Alaska and Hawaii. And here's their definition of states within the context of that regulation. State. The term state includes the District of Columbia, Puerto Rico, Guam, and the Virgin Islands of the United States. Do you see states of the Union in there? So the continental United States means the District of Columbia and nothing else, people. And why do they do that? Because they don't have jurisdiction in a constitutional state. They never have, with very few exceptions. Okay, and we talk about that in our federal jurisdiction pamphlet, what those exceptions are. But income taxes are an example of an area where it's not accepted. Okay, substituting states definition in red, within that regulation we showed earlier, the term continental United States means the District of Columbia and the District of Columbia, Puerto Rico, Guam, Virgin Islands, except Alaska and Hawaii. Okay, so there you go. So within the statutory context, it always means federal territory and excludes states of the Union. Okay, and the Constitution, on the other hand, was the opposite. It always includes states of the Union and excludes federal territory. It always works that way, and there are very few exceptions. United States in statutes. The rules of statutory construction forbid adding anything to the statutes, and statutory definitions supersede rather than enlarge the ordinary definitions. And here's the Stenberg quote we read to you earlier. That's one example. And here's another one from Black's Law Dictionary, 6th edition. Expressio unius est exclusio alterius, a maxim of statutory interpretation meaning that the expression of one thing is the exclusion of another. Mention of one thing implies exclusion of another. When certain persons or things are specified in law, a contract or will, an intention to exclude all others from its operation may be inferred. So you have a right to presume that if they didn't mention it, it's not included. Okay, and notice earlier in the definition of United States, they did not include states of the Union. And why? Because they can't. They don't have civil jurisdiction there. Confusing domicile with nationality. This is another type of legal propaganda, so to speak. Okay? The terms domicile and citizenship and nationality are maliciously and carelessly used by government employees on forms and in ordinary speech. They are most often all falsely presumed to be equivalent at the federal level, even though they are not. Confusion over these terms even infects the freedom community and causes needless arguments about citizenship or whether the 14th Amendment made us all federal slaves or federal jurisdiction in general. An understanding about the distinctions between these two words, domicile and nationality, and how they interact with each other is crucial to preventing government usurpations and arguments in the freedom community. Confusing domicile with nationality. And here are the distinctions. Be very aware of these distinctions, please. Nationality is a political status. It is defined in the Constitution, which is a political document. And it is synonymous with being a national within statutory law. Not a citizen, but a national. And it is associated with a specific country. And it is a product of birth or naturalization and not domicile. Okay, so the domicile is not related to nationality. They're completely different things. Domicile, on the other hand, is a civil or legal status rather than a political status. It cannot be acquired without the express consent of the person, and it is not even addressed in the Constitution, and it is defined by civil statutory law rather than the Constitution, and it is in no way connected with one's nationality, and it is usually connected with the word person, citizen, resident, or inhabitant in statutory law. You cannot be any of those without first having a domicile within the jurisdiction, and there's only one exception, which is the Foreign Sovereign Immunities Act and the purposeful availment or long-arm statutes, and it is associated with a specific country and a state rather than a county and a state rather than a country. Okay, so you can have a domicile in a county, but you can't have a domicile in a country. Okay, that's completely different, and it implies one is, and by that we really mean a municipality. Okay, domicile is always associated with a municipality, a county usually. Okay, not a country, and it implies one is a subject of a specific municipal but not national government. Nationality and domicile are not equivalent. Please remember that. Main points of citizenship confusion. Nationality is defined in Black's Law Dictionary as that quality or character which arises from the fact of a person's belonging to a nation or a state. Nationality determines their political status of the individual, especially with reference to allegiance, while domicile determines their civil, that is, legal or statutory status. Nationality arises either by birth or naturalization. Black's 6th, 1990, page 1025. By political status above, they mean status under the Constitution and not statutory law, and nationality and not domicile. Okay, why? Because the Constitution is a political document. It's not a legal document for you. It's not law for you. It's law for the government. So it's a political document. By civil status above, they mean domiciled on federal territory and a statutory, that is U.S. citizen, subject to the civil, that is acts of Congress, per 8 U.S.C. 1401, 26 U.S.C. 3121E, and 26 CFR 1.1-1C. And another example of a civil status, taxpayer, per 26 U.S.C. 7701A14, or driver under the Vehicle Code. And we could go on and on. Most statutory statuses you will find on government forms relate to your civil status, not your political status. Every government form presumes a civil and legal and statutory status and not a constitutional status. If they ask you whether you're a citizen on a government form, you should not presume that they mean the political status or your nationality. And the response then should be, I'm an alien, because they're talking in the statutory sense, not the constitutional sense. And here is a really useful chart that shows the relationship between your domicile, that is your civil legal status up here, and a lot of other factors, like your physical location, your tax status, the tax forms, and the relationship between your domicile and your nationality, okay, down here. Domestic and foreign nationals, okay? And by domestic nationals, we mean somebody who was born or naturalized in the country, United States. And a foreign national, we mean somebody who is born or naturalized in a country other than the constitutional United States, okay? So you can see that if the first column here is domicile within the federal zone. So if you're domiciled in the federal zone and you're born somewhere in the country, then you're a statutory citizen here, 8 U.S.C. 1401. If you then change your domicile to outside the federal territory, okay, you're domiciled within the federal zone, but then you temporarily change your location, but not your domicile, then you continue to be a statutory citizen abroad, 26 U.S.C. 911. But then if you change your domicile to a place outside of federal territory, for instance, if you change it to a constitutional state of the Union, or if you change it to a foreign country, then you become a non-citizen, a statutory non-citizen national. That's really important stuff. So you're not a citizen under federal law. If you're not a citizen, and by implication, you're also not a resident, because both of them imply a domicile on federal territory. So you become a non-citizen national, and in most federal forms, that would be reflected as an alien, okay, a statutory alien, because there's a difference between the definition of United States in Title 8 of the U.S. Code, which is citizens and aliens and nationality, and other titles of the code, such as Title 26. Okay. Likewise, if you're a foreign national and you're domiciled on federal territory, then you're a resident alien. Whereas if you're domiciled, if you change your domicile to a state of the union, then you become a non-resident alien individual if you're a public officer, or simply an alien if you're not a public officer. Moving on. If you want to make sure that you don't be victimized by this confusion between domicile and nationality, we've prepared forms that you can attach in various circumstances. The first one we like to use in court settings. Form 10.003, Citizenship, Domicile, and Tax Status Options. You can attach this to your initial response or your initial petition in any state or federal court to remove all confusion about your domicile and nationality. Okay, and likewise, affidavit of citizenship, domicile, and tax status, that would be used primarily in an administrative rather than legal context to attach to tax forms, withholding forms, citizenship, passport application forms, and so on. And this does the same thing in an administrative context. And finally, for further details on the scam of confusing domicile with nationality, see why the 14th Amendment is not a threat to your freedom. This is a subject often argued about in the freedom community, needlessly, we might add, because they don't understand the distinctions between domicile and nationality. And we'd like to eliminate that confusion so we can finally band together and agree on what's wrong and proceed from there. Another good source for details on this subject is why domicile and becoming a taxpayer require your consent. Form 05.002, and that talks about the distinctions between domicile and residence. They're not the same. And all the tricks that they play with domicile and how it's voluntary. Citizenship and Sovereignty course, Form 12.001, is a high-level overview of citizenship subjects if you'd like to delve into this more. Our detailed memorandum of law, why you are national, state national, and constitutional but not statutory citizen, Form 05.006, that goes into excruciating details about the distinction between the statutory context and the constitutional context, and being a statutory citizen and a constitutional citizen, which are completely mutually exclusive. They're not the same thing. And finally, we also have a set of citizenship diagrams for people that are visually minded and visual learners, where you can look at these diagrams and see for yourself with Venn diagrams all the relationships and how some are subsets of others, and all those get tied into all the statutory statuses you can have. So you can see how they interact between domicile and nationality. The next type of legal propaganda that we're going to talk about is confusing public rights with private rights. Politicians often try to confuse the two types of rights by calling both rights. And judges do this all the time too. And refusing to distinguish whether they are public or private. Okay? And because, as we said in our earlier courses, our third course, in particular, where we talked about status and rights and privileges, the two types of rights, public rights and private rights. We talk, the purpose of this deliberate confusion is to entice or deceive you to participate in government franchises in order to give up your rights and the protections of the Constitution and the common law. And here's an example of how that conversion occurs. Okay, the words, and this is out of the Supreme Court case of Paul versus Virginia. Okay, the words privileges and immunities, like the greater part of the legal phraseology of this country, have been carried over from the law of Great Britain and recur constantly either as a source or in equivalent expressions from the time of the Magna Carta. For all practical purposes, they are synonymous in meaning. And notice privileges and immunities, those are franchise terms. A red flag ought to come up when you see those. Those are both franchise terms, okay? And originally signified a peculiar right or private law. There we go again with that word, private law. Okay, privileges and immunities are always private, and meaning they only apply to a subset of the whole population. They don't apply to all citizens. They only apply to people who consent. Okay, you have to consent to private law before it's law for you, or before it has the quote force of law. Okay, so it says, and originally signified a peculiar right or private law conceded to particular persons or places, whereby a certain individual or class of individuals was exempted from the rigor of the common law. Now notice that phrase here, that word here, individual. You can't be an individual until you're subject to privileges and immunities. Otherwise, you're simply a man or a woman. Okay? That's how they reach you. That's how they convert private to public. Is they call you an individual and they make you a subject or a beneficiary of some franchise or privilege or immunity. It says privilege or immunity, and notice they also use the word rigor, okay, exempted from the rigor of the common law. So in other words, if you sign up for a franchise, you're not protected by the common law anymore, because it says exempted. In other words, and the common law enforces your private rights, just like the Constitution does. So at that point, you don't have any private rights in the context of that specific privilege or immunity. It says, privilege or immunity is conferred upon any person when he is invested with a legal claim to exercise of special or peculiar rights authorizing him to enjoy some particular advantage or exemption. And that advantage or exemption, by the way, completely violates the notion of equality and equal protection. So there's no equality or equal protection if you're receiving a special privilege or immunity that nobody else has. No, is there? You can't be equivalent. You can't be equal to an ordinary citizen if you're the subject of a privilege or immunity or franchise, just by definition. Note the term special or peculiar rights in that case. Anything that is special or peculiar is special law, is private law, and can acquire the force of law only by your express consent in some form. In other words, you have to agree to participate in the activity, the franchise, the privilege, the immunity, before your private rights can be converted to public rights and before you can lose your equality in relation to a real government. And it is being misrepresented if it is called law without adding the word private in front of it. Okay, so if they call, in the context of the vehicle code, if they say a driver has a quote right unquote to travel the public roadways, well, a driver is a public officer and a franchisee receiving a special privilege, and he has a private right to operate on the public roadways for hire, only for hire, okay, but he doesn't have a public right, and he doesn't have, and the vehicle code is not law for a person who is not a driver, quote unquote, and who is not engaged in the use of the public roadways for hire, for commercial gain. Okay? He's not a driver, he's not, quote, operating, he's not using a, quote, motor vehicle, unquote, and so on. All those terms are connected to the franchise and do not refer to private conduct. Why? Because they cannot regulate private conduct. Confusing public rights with private rights. To protect yourself from false presumptions about rights caused by this abuse of language, this confusion between public rights and private rights, we recommend doing the following. Presume that the right they are referring to is a public and not a private right, by default, and to insist that the right does not belong to you as a private person, and to ask them which of the two they mean, public or private. And if you don't get an answer, then continue to presume that it is a public right and privilege that you cannot participate in. Why? Because you have to surrender your equality, and you have to surrender the protection of the Constitution and the common law to participate. That's what Paul versus Virginia just said. For further information on the distinctions between public and private rights, see Government Instituted Slavery Using Franchises, Form 05.030. We also talked about this in our previous video 3 in this series, if you want to go back and review it. And here is the next type of legal propaganda. They like to confuse the body corporate with the body politic. Judges love to do this. Okay? All governments consist of both a body politic and a body corporate. And they're not a government if they don't have both of those. Okay? A de jure government. Okay? They may be a de facto government, but they're not a de jure government. A de facto government, for instance, is one that is only a body corporate with no body politic. Why? Because everybody agreed to become a franchisee employee or public officer, so there are no private people. That would be an example of a de facto government. Okay? But all de jure governments always have a body politic and a body corporate. To be, quote, in the body politic, unquote, is to be domiciled on the geographical land composing the body politic. Because you need three things to have a government: people, territory, and laws. Okay? You can't have a government without territory. And that territory has to be tied to people with the domicile. Because domicile is the method of that those people consent to be protected by those laws. And number two, to be in the body corporate, on the other hand, means to be serving as a public officer in the body corporate and as a franchisee. Okay? So you could, to say that a person is in, so you can be in the body corporate or you can be in the body politic, but you can't be both. Okay? Because you cannot, an employee cannot register to vote as an employee. Okay? A government employee. He has to register to vote as a private person, which means he's in the body politic rather than in the body corporate. It is very common for people in government to ask whether you were, quote, in the state, unquote. Courts do this all the time. And they play games with the address block on the forms you fill out as an excuse to make presumptions about whether you're, quote, in the state. Okay? They will also very commonly falsely presume that a statutory state always means a geographic place. It does not. In most cases, in fact, in most civil law, statutory law, the term state implies the corporation. So if you're in the corporation, meaning what that really means to be in the corporation is that you are a public officer working within the legal person, which is a corporation. Okay, the body corporate, so to speak. Okay, they may also refuse their burden of proving which of the above two contexts they mean by state. Just ask them sometime whether if they want to use that word, ask them what it means, and they're going to wiggle, and they're going to run like cockroaches with a light coming on when you start dealing with that issue, because it's a hot button. It totally blows up all their little presumption games, their religion games, their civil religion of socialism games. So it's a word game they love to play. And you can tell that they know that they're playing it because they don't want to talk about it. And they're hiding it. They're putting the fig leaf on. That's what lawyers do. That's their main job, risk control. And they do it by evading anything that would properly apply the law to your circumstances. And they may evade or refuse to answer questions from you about which of the two contexts they mean. That's what we just said. By doing the above, they are unlawfully enlarging government jurisdiction to reach private people otherwise beyond their control. In other words, they want to steal. They want to steal and destroy. They want to do the opposite of what governments were created to do, which is to protect your private rights. And the very first step, as we said, in protecting your private rights is to prevent them from being converted to public rights without your express written consent. All the just authority of the government, as the Declaration of Independence says, derives from the consent of the governed. Every time they talk to you, they ought to prove that you consented in that specific context. That should be the burden of proof they have to meet. And they don't like having to meet that burden of proof. If someone asks you if you are, quote, in this state, they could mean, are you consensually domiciled within the physical geography of the body politic, or they could mean, are you serving as a public officer franchisee in the body corporate? you can be legally within the body corporate as a legal person by serving as a public officer in the corporation. So this is what we would call a virtual state. The body corporate is a virtual state. Okay? It's virtual because it's not physical. It doesn't have a territory. It's just a legal person. Whereas over here, it's a real state. It's the body politic is a real state because it's connected to real territory. In the statutory law, the second option above is usually silently presumed by the judge or your government opponent because they can't regulate private people who don't have compacts or contracts with them. And the Supreme Court basically admitted that indirectly in Osborne versus Bank of the United States. Moving on with the confusing of body corporate with body politic, to avoid the adverse consequences of this malicious tactic, simply respond by saying, in answer to the question of whether you were, quote, in the state, you can say on the land but not in the state. This keeps your feet firmly planted on the land, protected by the Constitution and the common law. And you can say domiciled without the statutory United States and state in all government law. Some people even, under their own signatures and near their names, whenever they fill out a form, they might put on the land but not in the state. That's how you prevent this problem. And we talk about this fraud, this propaganda, this legal propaganda in Form 05.024 entitled Corporatization and Privatization of the Government. And the next type of legal propaganda, most commonly done by judges, is to confuse a compact or franchise with law. For instance, they call the vehicle code. They don't call it law, they call it code. Okay, now how does code acquire the, quote, force of law? And at what point does it become law? And for whom? Those are the questions you might want to ask in that kind of a circumstance. Law in a common law or classical sense applies equally to all because all are equal, just as Obama said earlier in video 1. A compact or franchise, which are agreements or contracts, only acquire the force of law and become, quote, law, binding on the parties after they consent. Before someone consents to a compact or franchise, it, number one, is not law for them and has no, quote, force of law. And number three, is nothing more than a proposed relationship requiring consent to acquire the, quote, force of law, unquote. Examples of franchises include the civil portions of the following: the family code, the vehicle code, and the tax code. In truth, compacts and franchises are private law, but not law as defined here. And we'll show you that on the next slide. Those who call compacts or franchises, quote, law without adding private in the front of it are deceiving you. And by refusing to put the word private in front of it, in effect, they're trying to deceive you into believing that it applies equally to all, even though it doesn't. Okay, so they're doing the fallacy of appealing to your ignorance and fallacy by equivocation, because they want you to think that it applies to a situation that it doesn't. Okay, they're switching the contexts again. And here's proof that we found in a book on the common law. And this law was by this book was entitled Readings on the History and System of Common Law, Roscoe Pound, 2nd edition, 1925. And this fellow was a Harvard law professor of all things. And here's what he said about this deception. And by the way, this is before the deception was as widespread as it is now. But we're just showing you all the word games they're playing. He says, municipal law, thus understood, is properly defined to be a rule of conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. It is also called a rule to distinguish it from a compact or agreement. For a compact is a promise proceeding from us. Law is a command directed to us. The language of a compact is, I will or will not do this. And by compact here, he means an agreement or contract, okay? That is, that of a law is, thou shalt or thou shalt not do it. It is true there is an obligation which a compact carries with it, equal in point of conscience to that of a law. But then the original of the obligation is different. In compacts, we ourselves determine and promise what shall be done before we are obligated to do it. In laws, we are obligated to act without ourselves determining or promising anything at all. Upon these accounts, law is defined to be a rule. Okay? So if they call the vehicle code or the tax code or the family code or the Social Security Act or any other franchise, if they call any of those law and they tell you that it's law for you, they're committing a fraud until they prove that you consented to it, because it only acquires the force of law with your consent. And we talked earlier in earlier video about this subject. You know, we quoted Ben Lowry where he says, well, we've been propagandized. You know, we've been brainwashed into believing that it's law, but it's really just a club. And this is how they fool you into joining the club, by playing games with the word law and by not preceding it with the proper terms, private or public, so that they can pretend, they can protect their right to pretend and to presume that it applies to everybody, because that's what they want. They want everybody to be their customer, now don't they? They're the customer of their, quote, protection racket, unquote. And they want you to pay, quote, taxes, which are really just protection money, to procure the right to be left alone by a mafia, okay? Here's another, and the next type of legal propaganda we hear often is court rulings used as propaganda. The rules of civil procedure dictate what law may be cited by the parties to a civil suit. See Federal Rule of Civil Procedure 17b. Most states have civil rules similar to the federal rules. And these rules require that only civil law from the domicile of the defendant may be cited. This civil law includes only civil statutes from the domicile of the defendant and case law where the defendant had a similar domicile. An example of this second one, case law where the defendant had a similar domicile, if they cite a case, they love to do this. They love to cite cases where it had the result they wanted, but the defendant didn't have your status. He was not, quote, similarly situated, unquote. For instance, they may say that you got to pay a tax or you have to obey the vehicle code, and then they'll cite a case that involved a driver, even though you're not a driver. Or they'll cite a case where the defendant was domiciled in, quote, in this state, unquote, meaning in the corporation as a public officer, when you aren't. And then they'll pretend like it's equivalent in your case. And it's up to you to gig them on that and point out that the case is irrelevant. And hopefully you'll do it before they even rule on the issue, so they don't play the game to begin with. And the forms on our site prevent this game. Lots of them. For instance, the federal pleading motion attachment on our litigation tools page prevents this problem. Moving on, states of the Union are legislatively but not constitutionally foreign in respect to the national government. Hence, no federal law may be cited, civil law, may be cited against a party domiciled in a constitutional but not statutory state. And there are those two contexts again, remember? We talked about constitutional and the statutory context, and they're mutually exclusive. They're completely different from each other. You know, you can be a state in the Constitution and yet not a state under federal law. You can be a citizen in the Constitution and yet not a citizen under federal law, but rather a non-citizen national. So always be aware of context. Context, and context are the only thing that matter in jurisdiction and in court. The only exception to the above is that if the party is representing a government corporation, in which case his domicile becomes that of the government that granted the corporate franchise. And this, too, is recognized in Federal Rule of Civil Procedure 17b up here, because there are only two ways they can reach you with their civil laws. You either have to have a domicile on federal territory, or you have to represent an entity that's domiciled on federal territory and which was created by the government, meaning a federal corporation and not a state corporation. Those are the only two ways they can reach you under the civil law in a civil court, a federal civil court. And here's the proof. Okay? Federal Rules of Civil Procedure 17b. Capacity to sue or be sued. Capacity to sue or be sued is determined as follows. Number one, for an individual who is not acting in a representative capacity, meaning not a public officer in the government or a corporation, by the law of the individual's domicile, the human being, okay? And for a corporation that is in the United States in this case, or its officers on official duty representing the corporation, by the law under which it was organized, that is the laws of the District of Columbia. All federal corporations are organized under the laws of the District of Columbia and not elsewhere, and not under state law, for instance. Okay, so those are the only two ways that they can reach you with federal law, okay? And if they can't reach you with federal law under items B1 and B2 here, then they have to apply the laws of the state, item 3 here, by the law of the state where the court is located, okay? So if you don't have a domicile in federal territory and you're not representing a federal corporation as an officer of a corporation or a public officer, then they have to apply state law and not federal law, okay? Keep that in mind. Extremely important, people. Okay? Any of the following tactics constitute an abuse of case law or civil law as a means of propaganda and result in a void judgment. Okay? The law has to apply to you. In other words, it has to have the force of law before it's relevant to you and your circumstances and the case you're involved in. Any attempt to cite civil statutes from a territory in which the party is not domiciled. Why? Because domicile requires your consent. If you don't want to be protected by those civil laws, and because you're not a member of the club, then you're a non-resident. If you're a non-resident, they can't reach you. And the only way they can evade that requirement is to apply the minimum context doctrine of the international shoe case. You know, where you had to purposefully avail yourself of commerce within the jurisdiction of that venue, okay? Here's another example of an attempt to abuse law as propaganda, civil law. Any attempt to cite a case law against you which involved parties who do not have the same domicile or circumstances as you, okay? If you're not domiciled on federal territory and the case they cited, the defendant was, and you can tell whether he was or she was, because if they treat them as a taxpayer or driver, then they were, by definition, okay? Number 3, any attempt to imply that the civil law has the, quote, force of law against a non-resident party who is not, quote, purposefully availing himself, unquote, of commerce within the forum, okay? So if you're a non-resident party, for instance, if you're a person in a State of the Union, and you're engaging in business activities on federal territory with people domiciled on federal territory, between you and the other party, you do not have an agreement that you won't apply federal law, then you're purposefully availing yourself. In other words, the other party wants to be protected by the laws of his jurisdiction on federal territory, and therefore you agree to be subject to those if you do business with him. That's how it works. And any attempt to treat a non-resident as a resident for any subject matter that they are not purposefully availing themselves of commerce in the forum. You know, so the minimum context doctrine only applies federal law to that specific case. In other words, if you signed a contract with somebody to do business with them who was domiciled on federal territory, and you're domiciled in a constitutional state, meaning you're an alien, a non-resident alien, but not an individual, then only for the purposes of that transaction do you waive sovereign immunity and agree to be sued in a federal court, and for no other purpose. So in that sense, you become a resident for that special purpose only, and a non-resident for all other purposes. And let's say, you know, for instance, you signed a contract, and the fact that you signed a contract with that person, but you're not domiciled there, then he could take you into court, in a federal court, to argue about the contract. But on the other hand, the vehicle code of whatever that jurisdiction is, the District of Columbia or whatever, that vehicle code will not apply to you because it doesn't relate to that specific transaction. That's what they mean. Specific violations which occur for the above abuses. Violation of the separation of powers because the court is acting in a political rather than a legal mode as an agency within the executive branch. Okay, in other words, they're applying law to a non-resident. They're, in everything that happens outside that jurisdiction or that venue against a non-resident is political in nature. They can only interact with non-resident states and non-resident parties, who have a foreign domicile. They can only interact with those people in a political capacity. That's it. And they can't act in a political capacity. Okay, and the way they skirt that is with the minimum context doctrine, and no other method is available for them to assert or to enforce law, their law, the law of that particular venue against a non-resident. An example, okay, it's also a violation of due process. Okay, an example, okay, if you could be domiciled in a constitutional state, but you can't enforce, let's say you're domiciled in California, okay? Can you enforce the laws of California against a Chinaman who's domiciled in China just because, even though he's not doing any business with you, and therefore you don't need protection? Okay, do the laws of California apply to a Chinaman anywhere in China? And the answer is no. Why? Because they don't have a domicile in California, number one, so that you can't apply the civil laws of that jurisdiction to the foreign party. Okay, so by the way, states of the Union, such as California and China, are on an equal footing in relation to the national government. Both of them are legislatively foreign in respect to the national government, with very few exceptions. And we talk about all of those exceptions in this document, Federal Jurisdiction Form 05.018. Another type of legal propaganda that judges and government prosecutors just love to use is they use the word frivolous all the time, okay? And it's closely related to the abuse of law as propaganda. They'll call you frivolous, and it's used mainly by judges and administrative personnel, especially the IRS, okay? And here's how they abuse this term. Most of the time, the term really means that you're a heretic who won't participate in their religion of presumption and servitude. In other words, you don't want to be a customer, and essentially they're saying, well, we don't like you and you're a heretic and you have to participate anyway. Really. I mean, that's really what it boils down to, is they want to enforce their club rules against a non-member of the club, which is just a polite way of saying they're thieves and liars and they're stealing from you. That's all. And by the way, if they can do it, guess what? Under the concept of equal protection, you can too. You can have your own anti-franchise, and you can say that their attempts to evade obligations of your franchise are frivolous. And all you got to do is emulate their behavior and let them argue that you can't do it, which indirectly causes them to argue that they can't do it either. That's what Sun Tzu would do. You emulate the chief strength of your enemy. Whatever their greatest strength is, you imitate it, and you let them try to circumvent that, and in a sense, they'll solve the problem for you. They'll defeat themselves. You turn their own strength against them. When this term is used without providing legal evidence why your approach is based on false information or false inferences, the term is being abused to violate due process of law. It is a violation of due process of law to say your statement is false without evidence on the record proving that it's false. Okay? So if a judge calls you frivolous, first of all, he has to present evidence. Otherwise, he's engaging in a political opinion, isn't he? If there's no evidence on the record that it's false, and by the way, the only party who could present that evidence is the opposing party and not the judge. If the opposing party doesn't present any evidence to prove that it's false, the judge can't. He's not a fact witness. All he can do is cite the law, because the law itself is evidence, okay? But he's not a fact witness in the case. And he's taking sides if he becomes a fact witness. He's just a coach. So all he can do is ask your opposing party to present evidence that your approach is false. Okay? And they seldom do that. So if they never go beyond the point of simply saying that it's frivolous and they never present any evidence, essentially they're the frivolous one because they're proceeding without evidence based on opinion and not in belief rather than facts. Okay? Keep that in mind. Even when evidence proving the falseness of your approach is presented, usually it violates Federal Rule 17b because it does not derive from your domicile and is therefore irrelevant and in fact frivolous. Okay? If Federal Rule 17b says you either have to have a domicile on their territory or you have to represent an entity that has a domicile, okay, and all they ever present is statutes that don't apply to you because you don't have a domicile, or case law that derives from parties who are not domiciled on federal territory, then they're the frivolous ones. That's how the game works. So, how do we defend against charges of being frivolous? What you have to do is you warn your opponent in your correspondence before they respond that they must provide legal evidence signed under penalty of perjury. And they never do that, so there's no basis to believe anything. If it's not signed under penalty of perjury, it's not evidence. And if it's not evidence, it's just an opinion. And courts cannot entertain political opinions based on, or political questions based on opinions. Opinions are not evidence. And so there's no evidence in the record if it's not signed under penalty of perjury. And they never sign it under penalty of perjury. So indirectly, the courts are essentially political animals in the executive branch if they won't talk about the facts or the law. And that's a violation of the separation of powers. They cannot act. A real constitutional court cannot act in a political capacity. On the other hand, a franchise court can. Okay, and you should never even set foot in a franchise court, and you should challenge jurisdiction in a franchise court because you're not allowed to participate in franchises if you're not a public officer before you got in there. And you can't elect yourself into office with a tax form or any kind of government form. You have to already be lawfully appointed or elected. Or, here are other ways. The evidence they present in a civil dispute must derive from your domicile, which means no federal law, and that all cases cited must involve similarly domiciled parties. In other words, they have to be domiciled in a state and not on federal territory. And they always break this rule. And finally, if you aren't domiciled on federal territory and aren't representing an entity so domiciled, then federal law is irrelevant and inapposite, as the judges would like to say. They like to use that word, inapposite. Okay? Another technique for dealing with a charge of frivolous is to define the term frivolous on every form you submit to mean truthful, accurate, and consistent with prevailing law. Our federal pleading and motion attachment does that. So then essentially you stole their word and they can't use it anymore. And they can't redefine it. You know why? Because under 28 U.S.C. 2201A, judges cannot entertain declaratory judgments in the context of taxes. So they can't redefine it for you. They're not fact witnesses, so they can't provide another definition. And the U.S. attorney is not a fact witness either. So there are no other witnesses. You're the only one who could present evidence in such a case. And if you define all the terms under penalty of perjury, they can't contradict those definitions. So the definitions have to stand because they're not fact witnesses. And other defensive tactics, okay? Defensive administrative tactic. The following form makes it difficult for administrative personnel to use the term frivolous. Tax form attachment. We define the term on the form so that if they use that, they're essentially agreeing with you. We define it as truthful, accurate, and consistent with prevailing law. So if they call you frivolous, we say, thank you for agreeing with us. There's no dispute. Now give us our money back. Another good tactic in a court setting, defensive court tactic, is the following. The federal pleading and motion attachment, as we said earlier. Okay, this basically defines it in the court record. And you should do it at the commencement of the action. Okay. For more information about this subject, see meaning of the word frivolous. Form 05.027. The next, and also a frequent method of legal propaganda by judges and attorneys, is to identify you as an individual rather than a man or a woman. Public servants, and especially law enforcement personnel, have been conditioned to refer to biological men and women as, quote, individuals. Watch a few police shows and you'll see that. Why is that? Why can't they just say man or woman? Why do they have to use person or individual? Okay, unless they want to basically enforce law that doesn't apply to that person. The only block that a man or a woman filling out a government form can check is individual rather than simply private man or private woman. This is true, for instance, on the IRS form W8BN in Block 3. So in other words, they don't offer you any other choices. The only choice they give you is individual, or at least that's the only choice they give you in the if you are in fact a man or a woman, a private man or a woman. So you essentially you have to launder your identity. You have to admit a status you don't have, that you don't want even, if you want to fill out their form. And a statutory individual in the Internal Revenue Code is a public office in the government. See Form 05.008. The purpose of converting men or women to individuals is to recruit them as public officers in the government, subject to statutory law. Okay? That's why the police like to use individual. That's why the judges love to use it. Okay? But if they enforce the statutory status of individual against you, they're engaging in eminent domain, which is unconstitutional in every state of the Union. And the eminent domain occurs because the public rights that attach to the status are the property that's being stolen from you. And they're thieves to act in such a presumptuous way. And they're also violating due process of law. The U.S. Supreme Court refers to the word individual as a corporation soul. Okay? So that's why they want you to be an individual. They want you to pretend like you're an officer of their corporation, that you're an employee, so they can regulate you as a public officer. At common law, and here's a Supreme Court case, I can't even pronounce that name there. At common law, a corporation was an artificial person endowed with the legal capacity of perpetual succession, consisting either of a single individual, termed a corporation soul, or of a collection of several individuals, corporation aggregate. So that is what an individual is. It's a corporation, and it's a corporation soul. So the office of person is the office you're filling, and that, or the office of individual, or the office of taxpayer, or the office of spouse under the family code, or the office of driver under the vehicle code. Those are all corporation souls created under a franchise, and they're public rights, and they're enforced in a franchise court, in the executive branch, not the judicial branch. So that basically concludes all of the various types of the main types, certainly not all, but most of the main types of legal propaganda chronically abused by judges, corrupt judges, and attorneys, U.S. attorneys, and district attorneys, and so on, in traffic court, and family court, and tax court, and so on. Okay, but God predicted this was going to happen, and here's what he said: 2 Thessalonians 2:3-17. For the mystery of lawlessness, and by lawlessness he means here, really, people that enforce their own will instead of what the written law says, by adding to the definitions or switching the context with equivocation or any number of other different things. That's all lawlessness is what it is. So the mystery of lawlessness is already at work. Only he, that is God, who restrains will now do so until he is taken out of the way. And then the lawless one, Satan. So Satan is the ultimate lawless person. And everybody who advocates, who plays all these little propaganda games, judges, attorneys, administrative personnel in the government, they're all Satan worshipers. As a matter of fact, that's why he says Satan is the lawless one, because we even refer to IRS as individuals representing Satan. So he says, and then the lawless one, Satan, will be revealed, whom the Lord will consume with the breath of his mouth and destroy with the brightness of his coming. The coming of the lawless one, Satan, is according to the working of Satan, with all power, signs, and lying wonders. There's those lying wonders. Propaganda. That's what lying wonders means here. Propaganda. Deceit. Okay? And with all unrighteous deception. Ooh, there's that word again, deception. Among those who perish, because they did not receive the love of the truth, that they might be saved. Okay, so people who don't want to hear the truth, or who don't have the love of truth, want to be seduced by propaganda. They want to hear what benefits them personally, and which does not honor the Lord, and which violates what the Lord wants. Okay, and for this reason God will send them strong delusion from their own government, that they should believe a lie, that they all may be condemned who did not believe the truth, but had pleasure in unrighteousness. And by unrighteousness here, they can only mean lawlessness, self-gratification, doing what feels good instead of what is good under God's authority. Remedies. Turn off. So how do we develop this love of the truth that God was talking about, so that we don't perish, so that we aren't judged, so that we aren't victimized by the presumptuous civil religion of socialism that a corrupted government is propagating? And the answer is, turn off the stinking TV and take ownership over your mind and thoughts. Don't let other people dictate what you're going to think or what you believe. Train yourself to recognize fallacies of every kind in every context. You know, when you hear it on the TV, when you're listening to a political speech, when somebody working in the government or in a public school says something, you should always question authority. Always. Okay? It's a duty of a citizen to question authority, according to Ben Franklin. And if you're forced to watch TV, practice verbally arguing with every speaker who deceives you. Talk to the TV. Use those brain cells of yours. Don't just sit there and get programmed, okay? Use it as an opportunity to engage in rhetoric, okay? Even if nobody's listening, practice it. You know, you don't really understand it until you can speak it anyway. The language is the key to really understanding all this, because it's all abuse of language, isn't it? So practice. Read. Become an avid reader. Turn off the TV. Become a producer rather than a consumer of ideas. And next, we need to learn the words of art that lawyers use to deceive you. We have a catalog of all those words of art. In our sovereignty forms and instructions online, Form 10.004, cites by topic. And this is actually on the Family Guardian website, so it's not really ours, but it's a link to a list of all the words of arts. Go over those, study them carefully. You'll see the deception that's going on, and the equivocation that's used to switch the context between statutory and constitutional. And next, the next remedy is, every time a government worker uses an important word of art, ask them to clarify which context, statutory or constitutional, and which statutory definition they're presuming if the word has a statutory meaning. And learn the propaganda terms that politicians use to deceive you. And we have a whole catalog of all those terms. Anti-Thought Control Dictionary, Form 08.013 on our forms page. Next remedy, always question authority in every context. Don't just believe what people tell you. George Carlin says he doesn't believe anything the government says. And that's a very wise approach to life. And you should begin, and Thomas Jefferson would agree with him on that subject. Okay, Thomas Jefferson said that true freedom is based on jealousy and not confidence. Okay, don't ever trust anybody in the government, because they work for you. You wouldn't trust your employees, would you? Okay, you'd watch them. It's your job to watch them. You wouldn't trust your kids, you know, especially when they're younger. You'd watch them like a hawk to make sure they're off to a good footing. Begin every study of law with the definitions section first. Okay? Read the definitions first. It might interest you to know, for instance, that the Internal Revenue Code, the definitions are at the end of the code. I wonder why. Because they don't want you reading them. They're in section 7701. I mean, every other contract puts the definitions at the beginning, right? Well, why do they put it at the end of the contract? And the contract, by the way, the franchise contract, is 9,500 pages of what the former Treasury Secretary Paul O'Neill called, quote, gibberish, unquote. All right? So the Treasury Secretary himself called it gibberish. And why did he call it gibberish? Because the definitions are at the end. And they are at the end because they hope you'll never read them. So read the end first. And remember, the big print giveth and the small print taketh away. Read the small print first. In statutory language, the small print is the definitions. Hello? And finally, avoid corporate-controlled media. Reliable sources for news that are not corporate-controlled can be found at the Media and Intelligence page, Family Guardian website. And here's a link if you want to visit that page. Summary and conclusions of our discussion on propaganda. A corrupted government loves your money more than they love the job they were elected to do of protecting your private rights. They have dumbed down the populace on law and turned the legal profession into a priesthood that worships and obeys only rulers and governments instead of the sovereign people they work for or the law itself, as a matter of fact. And they have engaged in a systematic campaign to abuse law against non-residents as a form of propaganda, mind control, thought control, and even damage control. Okay? Political damage control. And courts have been unconstitutionally politicized by replacing them with franchise courts or boards, such as the tax court, the traffic court, and the family court, and moving them into the executive branch. And this is a denial of due process of law, because due process has to happen in a constitutional court. And you should never consent to a franchise and surrender your right to go into a constitutional court or invoke the common law or the Constitution itself. And you have to be unequal to do any of that. And you should never agree to be unequal. And they have used fallacious and deceptive publications to oversimplify the subject matter to deceive the public into alleged obligations they do not have. They have spun their terminology to make it politically unpopular to challenge their criminal activities. And the main type of criminal activity is the unlawful conversion of private rights into public rights without the informed consent of the owner. And the method of providing that information or informing the people is to say that participation is voluntary and will protect your right to volunteer. Do they ever do that? Do they ever tell you, yeah, you have a right to not volunteer? They'll say that, Social Security is voluntary, and yet they won't protect your right to not volunteer. And they also won't offer you a form to quit. Hello? They actually hide the forms to quit. What's up with that? Next thing they've done is when they are confronted with the evidence of criminal conspiracy against your rights, they claim ignorance and call you frivolous in order to deceitfully protect their plausible deniability. The remedy is to get educated on law and oppose their propaganda, politically, administratively, and in the courtroom. We provide a large and growing library of forms that fills your administrative record with uncontroverted evidence of their criminal activities and correctly defines all legal terms to render such propaganda ineffective and expose it for the fraud and the crime that it is. This serves as a strong defense against criminal prosecutions effected in the illegal and unconstitutional administration of the government. If you'd like to further information, then please consult the following forms and resources on our website. Further information about propaganda, government deception. Many of these forms are also useful for filing directly in a court record during litigation. Recommended reading and viewing, Family Guardian website. Liberty University, Section 8, Resources to Rebut Government, Legal, and tax profession deception and false propaganda. Anti-thought control dictionary we mentioned earlier, Form 08.013. Policy document, rebutted arguments against this website, Form 08.011, which contains detailed rebuttals to specific false criticisms of our teachings. A book by Ezra Taft Benson entitled An Enemy Hath Done This. He goes into great detail about how the government has become corrupted. And he served in the government under a president. And rebutted version of the IRS, The Truth About Frivolous Arguments, Form 08.005. It rebuts the most common fraudulent statements by the IRS or individuals representing Satan. And finally, Flawed Tax Arguments to Avoid, Form 08.004. And this talks about both government and private sector flawed arguments about taxation, and pretty much leaves no defense for anybody who wants to argue with the information on our website, in the context, at least, of taxes. This concludes our presentation. Thank you so much for watching, and please visit our website and join our forums so that you can learn more about these subject matters and become a productive member fighting government corruption and tyranny at every stage. Thank you, and God bless you.